And greetings. Welcome to Privacy, the Right to be Let Alone, American Jurisprudence. We'll also be accompanied with Black's Law Dictionary, 9th edition, to make sure we leave no word behind. And without any further ado, let's get right down to it. I see we have Officer Murphy. Welcome. Good to see you here, Officer Murphy. And let's get right down to it. So, we're going to be looking into privacy. This is American Jurisprudence, 2nd edition. And this is the May 2023 update, by the way. So we're going to be looking at some very current information here. So let's start again with the scope and the summary of this. This article discusses the general law of privacy, which affords a tort action for damages resulting from an unlawful invasion of privacy, as distinguished from the constitutional right of privacy, which protects personal privacy against unlawful government invasion. It includes treatment of the nature, theory, and basis, juridical recognition and legislative pronouncement, extent and limitations of the general right of privacy, what acts or conduct constitute violations of the right, including intrusion upon seclusion, use of name or likeness, public disclosure of private facts, and publicity, placing a person in a false light. Defenses, including the statute of limitations, waiver or loss of the right, and absolute or conditional privileges, such as consent, practice and procedure, and remedies, including compensatory and punitive damages, and injunctive relief. So we're going to be covering a lot based on the general law of privacy. We're not going to be focusing much on governmental intrusion. That will be treated elsewhere, which we'll get to. Now, there's some federal aspects here. Federal law covers the following matters relating to the right of privacy, which are dealt with elsewhere. So these are some of the other places that we could look in: computers and internet. Oops. Oh, geez. Bear with me a moment here, guys. Oops. One more time. Give me a moment. Yeah, 1 second here. Jesus Christ. It's not one thing, it's another. All right. Oh, come on. One more time here. Oh, here we go. Let's refresh that cache. All right, there we go. And one more thing we want to do is bring our zoom level back here so we're not straining anyone's eyes. All right, let's continue here. So these are the areas that are treated elsewhere, so we're not going to be getting into any of this stuff here. Abortion, actions and damages for mental anguish or suffering, that's under damages and fright, shock, and mental disturbance. Census is invasion of privacy, which is under census. The COPA, whatever, the Children's Online Privacy Act. Condemnation as an act of privacy, that's under eminent domain. Constitutional right of privacy, and that's under constitutional law. And defamation, which is under libel and slander. So we're not going to be covering those tonight. Those are treated elsewhere within American jurisprudence. If there's any interest in some of these other topics, just leave a little something in the comments there, and we can consider that for a future live stream. All right, let's continue. So we got here also Electronics Communication Privacy Act, wiretapping. Let's see what else here. Adoption, prisoners, dead bodies, None of this we're going to be dealing with tonight. Right to die based on right to privacy, that's under death. All right. So let's get right down to it. General, common law right, and in general. So we have instruction and jury definition of invasion of privacy, which we also have under the pleading and practice forms, if we need to refer to that. All right, we have Island Walker Hick here. Welcome. Good to see you here. And peace to you as well. Right. So the right to privacy. The right to privacy has been defined as the right to be let alone, to be free from unwarranted publicity, and to live without unwarranted interference by the public in matters with which the public is not necessarily concerned. The right to privacy affords an individual a secret sphere of life from which he or she may exclude others. The right to privacy is not so much one of the right to total secrecy as is the right to define one's circle of intimacy or to choose who will see beneath the quotidian mask, and information disclosed to a few people may remain private. So an observation here is the tort of invasion of privacy is not intended to be duplicative of some other sort of tort. Rather, this is a tort which the focus is the right of a private person to be free from public gaze. So that's where an observation we can make here, and think about this as being it's not intended to be duplicative of some other tort. Rather, it's an individual cause here, which the focus is the right of a private person to be free from public gaze. Nice. And before we proceed any further, just to let you know, this is not to be intended as any kind of legal, lawful, professional information at all to be used or advised for anyone listening. This is strictly for educational, entertainment purposes only, and don't do this at home. Let's continue. Courts have a unique and essential role in protecting the individual's private life and space from well-intentioned but ultimately oppressive, insulting, degrading, and demeaning intrusions. Whether these intrusions come from the omnipresent forces of the state or from the equally omnipresent and inescapable forces of the market. So we have courts set with a unique and essential role in protecting an individual's private life and space, that sphere of privacy, from well-intentioned but ultimately oppressive, insulting, degrading, and demeaning intrusions. So these are operative words here: oppressive, insulting, degrading, and demeaning intrusions. Whether they come from omnipresent forces of the state or from the equally omnipresent and inescapable forces of the market. The rationale behind recognizing the tort of invasion of privacy is that the right to privacy is an integral part of our humanity. One has a public persona, exposed and active, and a private persona, guarded and preserved. And the heart of our liberty is choosing which parts of our lives will become public and which parts we hold close. Nice. So let's look at some of these footnotes here and 2009 case here. No special notes on these. This one here's a 2011, 1958, and a 2003. These newer cases, when we're talking about something like common law, right to privacy and such, it's a bit disturbing because this should be well-established case law. Seeing such recent holdings in this, it is troubling if it doesn't have directly to do with new types of media. It's usually judges sometimes interjecting their points of view into our law. All right, let's continue here with this. See, the right of privacy includes the right of an individual to keep secret his private communications, conversations, and affairs. And that's a 2014 case. First National Bank of Idaho, or Idaho First National Bank, State versus Nolan, Cuyahoga County in Ohio, and West Virginia. Charleston Area Medical Center Incorporated. Interesting. So these are pretty recent cases, 2014. Something to think about, guys. If you do want to do further research on these topics, these are cases that are rather recent, and you can always look at the transcripts of these. As to the acts which constitute a violation of the right, see sections 26 to 141, which we'll be going over partial parts of soon. All right, let's continue down so we can make it through this. Let's look at the basis on section 2 here, basis for the right of privacy. And if you haven't already, please hit the like and subscribe to the channel and hit the notification if you want to be notified for these live streams, as it will help the algorithm a little bit and kind of get the word out there. It seems we don't get as good of a turnout as we used to here. So I have a feeling that there's possibly maybe not considered the top priority to be promoted through the YouTube feed, I should say. So the more we could give it some feedback and let it know that it's the kind of content we like to view, perhaps it'll get the word out a little bit more and get more people involved. All right, let's continue here. Natural law. Let's see here. Let's see. We're going to start here. While some courts have taken the view that the right is predicated upon federal constitutional guarantees, other courts have drawn a sharp distinction between one's constitutional right of privacy, which defends the individual against government action, and the right to privacy that is involved in a tort action. According to such authority, while the constitutional right of privacy provides a limitation on governmental action, it is the right of privacy under tort law which confers personal rights on an individual as against other individuals. Natural law has also been suggested as the basis for the right of privacy. A few of the courts which expressly recognize the right of privacy have derived it from the root of some already established right, such as a property right. Moreover, there is a public policy interest in protecting the reputations of citizens. Nice. So we have here under footnote 1, the common law cause of action for invasion of privacy. All right, listen here. Includes the right to be let and left alone by virtue of the 4th, 5th, and 14th Amendments to the federal Constitution. And look who it is, one of our favorites, Ralph Nader versus General Motors Corporation. 1968. Unsafe at any speed. Yeah, one of the true American heroes, Ralph Nader. Good to see that up here. The common law cause of action for invasion of privacy includes the right to be left alone by virtue of the 4th, 5th, and 14th Amendments to the federal Constitution. Nice. Okay, so we're going to continue here on these footnotes. The Constitution protects privacy from governmental invasion, but protection of a person's general right of privacy, that is, his or her right to be let alone by other people, is left largely to the law of the individual states. So each state is going to have largely the laws to protect the general right of privacy. As to the distinction between constitutional right of privacy and the tort right of privacy, see Section 5, which we'll be to shortly. And this one here, the common law tort action for invasion of privacy is grounded in the same public policy interest that the legislature sought to advance by enacting the provision of the Freedom of Information Act, FOIA, governing access to private records, namely the interest in shielding entirely private matters from the public gaze. This is Payne versus City of Danbury, Connecticut, 2004, overruled on other grounds by Grady versus Town of Somers, Connecticut, 2009. On other grounds, though. Overruled on other grounds. So this case was overruled, however, it was other grounds. So the common law tort action for invasion of personal privacy is grounded in the same public policy interest that the legislature sought to advance. So we're looking at public policy interest advanced by the legislature when they enacted the provision of the Freedom of Information Act, which governed access to private records, namely the interest in shielding entirely private matters from the public gaze. So this is one of the intricacies here, where you have a commingling of private information within public records. And that's where we get to the tort. So before we go any further, I want to be clear here before I use my definition of tort. Let's visit our good friend Mr. Black, and let's look in here at the word tort and find out exactly what the current legal definition is going to be for tort. And it's going to take me a minute to get there, but the search is really bad in this thing, so we're going to do it the old-fashioned way, scrolling. And this one takes a while to scroll down a whole bunch because of the live stream, but we're going to get there. While we're here, is there any other questions or comments people would like to leave in the chat? And now's a good time we can catch up while this thing is catching up with the scroll bar. Here we go. Now it's getting there. Almost there. Let's see if we'll go quicker this way. Yeah, there's a lot of good stuff in a law dictionary, so it would be worth, if you can obtain a copy, hard copy. It's always good to have laying around, easy to flip through, because as you can see here, this is really cumbersome to flip through. And the search is terrible because it was scanned, so some of the words really aren't even in it. So we're getting there. We're on S, so tort's almost there. And if you see any of these good words here that catch your attention, like this is a good one here. I love this one. The Saudi defense, which is slaying. The some other dude did it defense, a claim that somebody else committed a crime, usually made by a criminal defendant who cannot identify the third party. Some other dude did it. That's a great one, slang. But it's in Black's Law. There's another good one I just saw over here, too, we got to look at. It was the SLAP. A strategic lawsuit against public participation. That is, a suit brought by a developer, corporate executive, or elected official to stifle those who protest against some type of high-dollar initiative or who take an adverse position on a public interest issue, often involving the environment, also termed SLAP suits. SLAP suit. So it's a strategic lawsuit against public participation. SLAP. It's an abbreviation, not necessarily slang. All right, so we've made our digression here. Let's get back to tort. Yes, that is very true. And I think if you're wise enough to look carefully, you'll find that practically every website will have disclaimers saying that they're not guaranteeing the accuracy or validity of any of the information there. It's just for informational purposes only and to reference the original documents for any legal matters. That's what you'll find in a lot of areas, which is kind of odd when you consider. I'll zoom this out a little bit here. It looks like some of it's getting cut off. All right, we're getting there, guys. Again, I apologize, pulling a lot of stuff. I hear the fans going on the computer. It takes a lot to scroll through this because it is a scanned document. We're almost there, though. Jeez. Well, there are a lot of S's, I'll say that. Here we go. This will be worth it because this is a complicated concept and I want to get it right for the live stream here. Just like title. Here we go. Almost there. All right, here we go. Let me make sure this is all on the screen. Tort from the 16th century. A civil wrong other than breach of contract, for which a remedy may be obtained, usually in the form of damages. So it's a civil wrong other than a breach of contract. A breach of a duty that the law imposes on persons who stand in a particular relation to one another. A branch of law dealing with such wrongs. So let's look here. To ask concerning any occurrence, is this a crime or is it a tort? Is, to borrow Sir James Stephen's apt illustration, no wiser than it would be to ask concerning a man, is he a father or a son? For he may well be both. We may define a tort as a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. It might also be here. I could zoom this in a bit more too for you guys because this is the. There we go. And get the screen cleared too would help. It might be possible to define a tort by enumerating the things that it is not. Okay, so here are things a tort is not. It is not a crime. It is not a breach of contract. That's 2. It is not necessarily concerned with property rights or problems of government, 3. But is the occupant of a large residuary field remaining, if these are taken out of the law. But this again is illusory, and the conception of a sort of legal garbage can to hold what can be put nowhere else is of no help. In the first place, tort is a field which pervades the entire law and is so interlocked at every point with property, contract, and other accepted classifications that, as a student of law soon discovers, the categories are quite arbitrary. In the second, there's a central theme, or basis, or idea, running through the cases of what are called torts, which, although difficult to put into words, does distinguish them in greater or less degree from other types of cases. So let's consider this. A lot of words here, making a lot of sense about what words can't describe or explain in this situation. They're trying to explain what it's not more than what it is, but it's also try to say that if we can understand, I guess, the commonalities that run through certain kinds of tort along with other types of actions here. So let's look at them. We have a business tort, a tort that impairs some aspect of an economic interest or business relationship and causes economic loss rather than property damage or bodily harm. Okay, so remember, we're talking about tort action for invasions of privacy. So some of these could be that overlap. Let's see. Let's read some of these through. Business torts include tortious interference with contractual relations. See, now, it's not the contract dispute, it's the tortious interference with the contractual relations. Intentional interference with prospective economic advantage. I could see this as being when you're trying to steal customers or something from someone else. I don't know. Unfair business practices, misappropriation of trade secrets, yes, and product disparagement. All right, so then we have constitutional tort, which comes from 1966, which is a violation of one's constitutional rights by a government officer, redressable by a civil action filed directly against the officer. Now, we're going to get into this stuff more under other topics. We have a dignitary tort, 1996. Geez, a tort involving injury to one's reputation or honor. Holy shit. In the few jurisdictions in which courts use the phrase dignitary tort, such as Maine, defamation is commonly cited as an example. Also erroneously termed dignitary tort. Dignitary tort. So it's not dignitary, it's dignitary. You guys got that? It's dignitary, not dignitary. Dignitary tort sounds kind of corny anyways. Let's continue here, guys, because we got to get through these torts and know a good understanding of what torts are, because we sure know what they're not, and it doesn't really give much description of what they are. So let's get some explanations of cases that do involve them. Environmental tort, a tort involving exposure to disagreeable or harmful environmental conditions, or harm to and degradation of an environment. Example given: the pouring of acid on golf greens. Jeez. An environmental tort is usually harmful to land rather than people, though people may find it unpleasant. Example given here is odors from a landfill. By contrast, toxic torts involve exposure to harmful substances that cause personal physical injury or disease. We have government tort, 1945, a tort committed by the government to an employee agent. This is a different topic. Intentional tort, 1860, a tort committed by someone acting with general or specific intent. Here we go. Examples include battery, false imprisonment, and trespass to land. Also termed willful tort, negligence. Cases, tort. Good. There's marital tort, one spouse against another. I think that would be under other ones in AmJur. Maritime tort, any tort within the admiralty jurisdiction. Mass tort, 1940, a civil wrong that injures many people. Examples include toxic emissions from a factory, the crash of a commercial airliner, and contamination from an industrial waste disposal site. That's mass tort. Also toxic tort, which we'll get to in a moment. Negligent tort, 1865, a tort committed by failure to observe the standard of care required by law under the circumstances. That's negligence. So negligence, the case would be negligent tort. Personal tort, 17th century, a tort involving or consisting in an injury to one's person, reputation, or feelings, as distinguished from an injury or damage to real or personal property. Interesting, from 17th century. A tort involving or consisting in an injury to one's person, reputation, or feelings. How do you injure the feelings? Preconception tort. Tort that is committed before the victim has been conceived. Prenatal tort. Okay, so we're getting into the other stuff there that we don't get into here because that's on another topic. We have prima facie tort, 1938, an unjustified, intentional infliction of harm on another person resulting in damages by one or more acts that would otherwise be lawful. Some jurisdictions have established this tort to provide a remedy for malicious deeds, especially in business and trade context, that are not actionable under traditional tort law. All right. I hope everyone's still there. We're going through lots of torts here, and this is going to help us be well versed, at least, in tort just by this time you're spending here. So please bear with me. Property tort, 1898. A tort involving damage to property. Public tort, 1949. A minor breach of the law, such as a parking violation. That, although it carries a criminal punishment, is considered a civil offense rather than a criminal one because it is merely a prohibited act and not inherently reprehensible conduct. Also termed civil offense. So public tort. Its recent is 1949. Wow. Quasi-tort, 1809. A wrong for which a non-perpetrator is held responsible. A tort for which one who did not directly commit it can nonetheless be found liable. As when an employer is held liable for a tort committed by an employee. Also spelt quasi-tort, without the hyphen. See vicarious liability under liability. All right. Sanctions tort, toxic tort, 1979. Okay, this is one we need to get back to. Civil wrong arising from exposure to a toxic substance, such as asbestos, radiation, or a hazardous waste. A toxic tort can be remedied by a civil lawsuit, usually a class action, or by an administrative action. Mass tort, environmental tort, cases, negligence, product liability, willful tort, see intentional tort, we saw that, and one of my favorites, tortfeasor. The tortfeasor, 17th century, one who commits a tort, a wrongdoer. We know there's plenty of tortfeasors around there, especially those concurrent tortfeasors from 1921, two or more tortfeasors whose simultaneous actions cause injury to a third party. Such tortfeasors are jointly and severally liable. Nice. So tortfeasors is just a favorite word of mine. Let's get back to the topic before we digress any further. Thank you for bearing with me there. Let's get back to the American jurisprudence. So back here we saw here, town of Danbury, 2004. That would be an interesting Connecticut, interesting case to look up. Let's see if I can pull that one up for the next one. All right, let's continue here. Section 3, recognition of the right of privacy. All right, if you guys are still there, if the audio is still good, please let me know, and that the stream is still heading out there into YouTube land. It seems like the stream health looks good on this end. Just want to make sure. Let's proceed. Many courts have ruled that there is a common law right of privacy, the invasion of which is a tort, which gives rise to a cause of action. In other states, the courts have denied the existence of any common law right of privacy, the invasion of which, independently of other considerations, will constitute a tort. Cumulative supplement here, the cases are actionable invasions of privacy, must be sufficiently serious in their nature, scope, and actual or potential impact to constitute an egregious breach of the social norms underlying the Privacy Act. Thus, the extent and gravity of the invasion is an indispensable consideration in assessing an alleged invasion of privacy. So that's a pretty good case here to look at. Here is Mesger versus Bick. and that's 2021, California. So very recent, October 13th, 2021, review denied. Interesting. So again, the actionable is a mouthful here, but let's try to break this down so it makes sense. All right, so we got actionable invasions of privacy. Must be sufficiently serious in their nature, scope, and actual or potential impact. So let's break this down. Must be sufficiently serious in both the nature of the invasion, the scope of the invasion, and actual or potential impact. So the impact it actually did or the impact it could do in the future to constitute an egregious breach of the social norms. Wow, of the social norms. So look at all the stuff that we need to have here to make it actionable. So we got to establish what social norms underlying the privacy right are. Thus, the extent and gravity of the invasion is an indispensable consideration in assessing an alleged invasion of privacy. So it's the extent and gravity of the invasion. That's the most important, or it's an indispensable area to consider when you're assessing any kind of invasion of privacy action. So let's look at the supplements here, or the footnotes to the supplement. Puerto Rico law, appeal dismissed, 96. So these are just the cases. The adoption by the voters in 1972 of the state constitutional amendment explicitly establishing the right of privacy as an inalienable right was intended to strengthen the right of privacy, which had already been established by court decisions. And that's California, 1979. And action based on the principle that an individual has the right to control the use of his or her name and image could not be maintained in Nebraska, whether denominated right to privacy or right to publicity. So an action based on the principle, so this is not a good angle here, guys. That an individual has the right to control the use of his or her name and image could not be maintained, in Nebraska at least, whether denominated right to privacy or right to publicity. Interesting. National Bank of Commerce, Trust and Savings. And that was 1974, applying Nebraska law. All right. Limitation of the right of privacy, Section 4. It looks blurry. Okay, you know why it looks blurry? Is because you need to refresh or get a higher resolution for what you're watching this. I'll wait a second here for you to do that. Christopher Real. If you just go to the settings, it should be a little gear icon, and then go to advanced there and just get the 720p, which should be the maximum for a live stream. And that'll give you a nice crisp image. And then we'll be good to go. So I can just get that thing off the screen. Hang on. Come on. Okay, there you are. All right, let's proceed. The right of privacy is a personal right, and the courts have not recognized a relational right to privacy. The right to privacy is not absolute, as it is qualified by the rights of others. It must be kept within its proper limits, and, in its exercise, must be made to accord with the rights of those who have other liberties, as well as the rights of any person who may be properly interested in the matters which are claimed to be of purely private concern. Subject to certain limitations, the workplace enjoys lesser privacy protections than a dwelling. So obviously at home you get more privacy than at work. Let's see here. As to who may assert and enforce the right of privacy, see sections 10 to 18. SunTrust Bank 2011, which is at footnote 2, the right of privacy, a personal right. Ah, wow. Relational right to privacy. Now that would be an interesting one to look up a little bit. All right. Yeah, we call them Untrust Bank. All right. Constitutional right of privacy against unlawful governmental invasion. The right of privacy as an independent and distinctive legal concept, and as one of the major fundamental constitutional rights, has two main aspects. One, the general law of privacy, which affords a tort action for damages resulting from an unlawful invasion of privacy. And two, the constitutional right of privacy, which protects personal privacy against unlawful governmental invasion. The federal Constitution promises that there is a realm of personal liberty which the government may not enter, and the result is a right of personal privacy, or a guarantee of certain areas or zones of privacy. The rights included within that zone are deemed fundamental and include activities related to marriage, procreation, contraception, family relationships, and child rearing. And education. Interesting. These are the rights included within that zone and are deemed fundamental. That's your activities related to education, child rearing, family relationships, and this other fun stuff. Interesting. They involve the most intimate and personal choices a person can make in his or her lifetime, and include choices central to the liberty protected by the 14th Amendment. So we go under constitutional law in second edition, section 650, and as to the constitutional right of privacy, see AmJur constitutional law, section 6. Defamation, distinguish from invasion of privacy. All right. An action for invasion of privacy differs from a libel action in that the former truth is not a defense, and it is not necessary to the cause of action to allege or prove special damages. All right, let's look at this and break it down a little bit here. An action for invasion of privacy differs from a libel action. In how way? The former, invasion of privacy action, is not a defense. And libel's a defense, huh? And it is not necessary to the cause of action to allege or prove special damages, whereas in a libel action, you do. Another significant difference is that a libel may rise from publication of a defamatory statement to only one person, whereas the invasion of privacy, at least by false light publicity, by definition, requires publicity of the falsehood to a substantial number of people. Wow. An action for, so this is a good important distinction here, right? Libel could be just one person that information is revealed to, yet invasion of privacy requires a substantial number of people. An action for invasion of privacy based on false light also differs from an action for defamation in that the former must involve the private affairs of the subject and cannot relate to any matter which is inherently public or legitimate interest to the public. Interesting here. So is based on the false light also differs. So an action for invasion of privacy based on false light also differs from an action in the former, that means the privacy action, must involve the private affairs. It can't relate to public matters or legitimate interest to the public matters. Cool. So that's some pretty nice distinctions there. And it's good when we can draw those distinctions because it really helps us. Oh yeah, thanks a lot, Matrix Transparency. I appreciate it. Really appreciate that. Yeah, I'm gonna have this up here too, so you can always just carry on your own time and listen to the rest of it. We're coming near the wow, we're already at the 2.5 hour mark, so that's where we're gonna sum it up pretty soon, and then we can do this in a part 2 soon. So let's just go through these footnotes here. So here's a nice little thing to have these differing factors here between libel and our invasion of privacy, and also the things of defamation. Defamation in private affairs are different kind of things. For private affairs has to be something which is private and not inherently public or legitimate interest to the public. So it's pretty good stuff here to know and have in your back pocket there. So let's continue on these footnotes. Many right of privacy cases could in fact have been brought as libel per quod actions, but several have been brought on both grounds. Interesting, and that's 67. When suing for invasion of privacy, resting on an unwarranted publication of intimate details of private lives, the plaintiff does not rely upon the inaccuracy of the content of a newspaper article, but instead charges that, even if accurate, the publication interferes with the plaintiff's right to be let alone. That's 1969, California. Nice. As to the effect of the truthfulness of a statement, see section 142. As to libel and slander, generally, see AmJur libel and slander, yeah, okay. As to pleading and proof of special damages in an invasion of privacy action, special damages, pleading and proof of special damages, see section 205. So we'll have to come back to that section on a later stream. As to invasion of privacy by publicity, placing a person in a false light, see sections 102 to 138. And section 106, as to the effect of pleading defamation, see section 204. All right, and so this looks like a good place we could stop off because this looks like an interesting topic to start the new one on, and it carries off where we just were. I think we can really sit there and ingest what we've learned about the distinguishing factors in finding our cause of action between things like defamation and libel and invasion of privacy, which is the central topic of this stream here. So by having a clear understanding of these distinctions, we can really know clearly which cases would involve true invasion of privacy causes of action. And again, now we also have a better idea of the tort actions and how they relate to invasion of privacy actions. So on that note, I would like to thank everyone for coming on tonight and spending time on the live stream here. Again, as I always like to say, it's a lot of things out there in the YouTube universe that could occupy your time and attention. But the fact that you guys are here show that you are willing to put some of that knowledge into action and learn about where the rubber meets the road and one of the most powerful tools we still have available to us in justice, which is our American jurisprudence. The more we know and respect and treasure this, the more we're going to see the power that is been found through generations, and to keep it alive for the ones to come in posterity. So again, I thank you all for coming. Please subscribe and hit the bell notification for the channel so you could be alerted to the next one. And I'm going to try and keep these up regularly again and get back into the swing of doing the American jurisprudence and other things related to our personal liberties and progressing them as far as we can. Again, I thank you all, and I'll see you all in the next one. Peace out.